Hi, I'm Dahlia Lithwick. This is Amicus, Slate's podcast about the courts, the law, and the U.S. Supreme Court. We are releasing this extra episode of Amicus on Tuesday afternoon because the tsunami of cases now hitting the Supreme Court on this question of the Alien Enemies Act and a black site in El Salvador seems to be coming to a head at the High Court this week, culminating in another unsigned per curiam order that came down Monday evening in a case we've been monitoring since its inception on March 15th, when the administration tossed several hundred Venezuelan migrants onto planes and sent them to the CICOT mega prison in El Salvador under exceedingly dubious legal authority. On Monday night, the Supreme Court, by a 5-4 margin, said, bygones, we're going to let the government go ahead, keep doing what they're doing because those renditioned prisoners, none of whom is an enemy alien in a declared war against the United States, filed suit the wrong way in the wrong court. Oh well, mistakes were made. Joining us to discuss what I think is a really big deal that is getting lost in financial news is Slate senior writer Mark Joseph Stern, who stayed up really late Monday night writing about this. Hi, Mark.
Hi, Dahlia.
So listen, there's two distinct cases that are getting a lot of attention. They have overlapping issues, but they are two very different cases. One is the case of Kilmar Abrego Garcia. We discussed that case with his lawyer on this weekend's show. The other is this class action suit that has been in front of Judge James Boasberg in a D.C. courtroom. I think you and I have been covering this almost since it was filed. And the Supreme Court took action in both cases on Monday, a tiny step in one case, a huge step in the other. So I wonder, can we start with that Boasberg case? What did the court do on Monday evening?
So the court lifted the temporary restraining order that Judge Boasberg had issued, barring the Trump administration from continuing to deport Venezuelan migrants to El Salvador under the Alien Enemies Act. Judge Boasberg had certified this class action on behalf of these individuals, had issued this restraining order saying that the program was likely illegal. The government appealed and won at the Supreme Court, which said, nope, we are setting aside the restraining order. We are essentially dissolving the class action in effect, and we are ordering all of these plaintiffs to instead file much narrower habeas petitions. Why does that matter? The plaintiffs had raised these really broad claims in Judge Boasberg's court under the Fifth Amendment's Due Process Clause and the Administrative Procedure Act, arguing that this entire scheme was unlawful. But now they will have to file these individual petitions that are technically lawsuits against the warden or custodian of the prison where they're being held, arguing that they are being held unlawfully. That is what a petition for habeas corpus is, and it's just a much narrower, more inefficient way to bring a challenge here. And also, we can get into this, it doesn't make a ton of sense because these individuals are not actually asking to be released from their detention centers in Texas, which is what a traditional habeas suit would look like. They are just asking not to get sent to El Salvador and to be confined in the United States instead of a foreign country. And yet the Supreme Court said, nope, sorry, this all has to go under habeas corpus. In the districts of their confinement, which for those individuals still being held in the United States who have not yet been sent to El Salvador, is South Texas. That is, of course, a district filled with Trump-appointed super conservative judges. And it is a district that falls within the hard right Fifth U.S. Circuit Court of Appeals. So all of these plaintiffs, the named plaintiffs, the entire class of migrants affected here, they have effectively been thrown out of Judge Boasberg's federal courtroom in D.C., and they have been told to try their luck elsewhere, probably one by one, not through a class action, not through a very broad suit under due process or the Administrative Procedure Act, but instead as a habeas petition in Texas District Court.
Is it worth stopping for a minute to just note that very few of these detainees have a lawyer on speed dial, can afford a lawyer, have family members who can say, hey, here's your habeas lawyer. In other words, instead of being swept up in a class where they all suffer similar harms and there's a similar constitutional injury, the very notion that each and every one of these people has access to and the ability to seek legal representation in a habeas case is in and of itself kind of bonkers, Mark.
It's ridiculous. The entire point of this class action was, as you said, to sweep up everyone and to raise these very broad claims on the merits, saying that this invocation of the Alien Enemies Act is unlawful, this denial of due process is just fundamentally illegal, and that the entire government scheme in effect here has to be restrained. That was the magic of Judge Boasberg's restraining order. And so with it set aside and with all these plaintiffs being told, sorry, go to Texas, they're going to be stuck trying to find lawyers, trying to find translators, racing to the courthouse to file these petitions, and then dealing with a government that has at every turn said, we want to deport these people as fast as possible, and shown no interest or respect in their own rights to protest their rendition to El Salvador.
Slate Plus members can access the full interview right now. You can subscribe to Slate Plus directly from the Amicus show page on Apple Podcasts and Spotify, or you can visit slate.com/Amicus Plus to get access wherever you listen. We'll be back with your regularly scheduled Amicus episode on Saturday morning. Until then, take good care.